became codified under the kingdom, and then now are adopted by the state. Uncle Kama, get a picture of you. It's from Lahela, your Opihi. Anyway, so another law is Hawaii Revised Statute Section 1-1, and this was part of the formation of the judiciary during the kingdom days. And basically they're saying, yeah, we're going to use the court cases of America and England as one guide for us. But where they conflict with Hawaiian custom and usage, then that's going to, Hawaiian usage and the customs of our people is what's going to make the decision, what's going to inform the law. So that's what Hawaii Revised Statutes is. And it includes greater rights than just getting tea leaf and aho corn and timber and all that. It's being able to gather opihi. So long as you can show that it's a customary practice, then it falls under the protection of Hawaii Revised Statute 1-1. So this understanding governs all the courts to this day in the state of Hawaii. And this was a kingdom law. So there are implications for our own understanding here. So as these different cases have been coming up, one of the things that they realize is they gotta go ask the Hawaiian, they gotta go ask the Kama'aina, what is the custom? So that's how the courts have to rule. And basically what they're saying is, so this case is the Ashford case. And this was a case of Molokai in the Ahupua of Kainanu, and this guy Ashford wanted to make his own private beach. And so he got one land surveyor, and on the deed it said Makikai along the sea. And so he wanted the land surveyor to survey his land, and basically the surveyor said, oh, Makikai means, you know, the high water mark or something like that. And essentially he was going to get his own private beach if the court followed the land surveyor's estimation. So this guy is a licensed guy, got trained as a surveyor. But the court said, I like to hear from the Kama'aina, I like to hear from the old timer what Makikai mean. And so the old timer said, well, you know, where I'm going to park my canoe, and I can park them where the wash of the waves will take my canoe out. I'm going to park my canoe where the Nauhaka is growing, you know, the vegetation line. So what did the Hawaii Supreme Court say? They said, I agree with you, Kama'aina. You want an expert. You want an expert above this licensed land surveyor trained in Western way of surveying. You know the palena, you know the boundaries. So that's why there is no private beach in Hawaii. Now, then there was a case in Kauai because some snowbirds said, well, I'm going to make one false vegetation line. I'm going to plant naupaka in the water. And so he said, oh, sorry about vegetation line, but you're not allowed. And the court said, you cannot plant no false vegetation line. You will look the original vegetation line. So that's how strong Kama'aina expert testimony is. So your ike, your expertise is admitted into evidence in a court of law as valid and superior to the guy with the Western palapala. So that's important to know. Article 12, Section 7 of the Hawaii State Constitution basically reaffirms and protects these traditional and customary rights of Hawaiian native Ahupua tenants for the subsistence, cultural, and religious practices. But they are also subject to reasonable regulation by the state. Okay, so what does that mean? Well, let's look at some cases, some seminal cases in this area. So this is another case, Uncle Billy Kalipi of Molokai. Remember I was showing you my fishing grounds? Oh yeah, you forgot that there was the Mexican self-destruct. But he's in the Ahupua next door to where my grandma lives. But he had like a lo'i in one Ahupua, like Ohia. But he resided, he lived in Ohia, but he also had family land in Manawai. And okay, Manae, East Molokai, is the length of Manae is about, I think 15 miles, okay? But there's 43 Ahupua'a. So you can understand how narrow these Ahupua'a are. It's like from Walapue to Manawai and Kahana Nui, Manawai and Ohia. If I had good pitching arm, I could toss on baseball and span 3 Ahupua'a. Okay. And so this is like really narrow. Okay, so the court never understand the polema, but basically they said Uncle Billy wanted to gather in Manawai. But they said, well, you're not an Ahupua'a tenant of Manawai, you're an Ahupua'a tenant of Ohia. So we're not going to recognize your kuleana rights in Manawai. And we're only going to recognize Hawaiian rights on undeveloped lands. Okay. That was undeveloped land, but they said his tenancy never fulfilled it. Hawaiian Ahupua'a tenancy. So that was the first case. But then after that came Pele Defense Fund, and that was Va'okele Opuna. And Va'okele Opuna rainforest, this was the geothermal issue. And so nobody would live in Va'okele Opuna, but a lot of people would go and gather there. In fact, Kalani's tutu, Papa Henry Awai, he gathered really important la'au that only exists over there for Hawaiian medicinal healing. So there was all this kama'aina expert testimony saying, yeah, we don't live there, but Va'okele Opuna is important to us. That's our custom to go access that for certain things. So then the court said, oh, maybe we gotta rethink the Kalipi case. If you guys can show that that's your tradition to go outside of your Ahupua'a residency to gather certain things, then we're going to recognize that. So this said the Constitution protects that. HRS 1-1 protects that. Then public access shoreline Hawaii came, and that was a case on the Big Island, and this guy Nancy, condominium developer, wanted to make his development in this area, sensitive area where there's these alkaline ponds where the opai ula go. And so there was one Hawaiian family that testified at the planning commission meeting saying, "No, give this permit because you're going to destroy these alkaline ponds." And I gather opai ula and I use them for bait. So what the planning commission said is, you Hawaiian, you know more rights that's distinct from the general public. So I'm not going to give you standing to intervene. But this thing went all the way to the Hawaii Supreme Court, and the Hawaii Supreme Court said Hawaiians have distinct rights different from the general public, and you were supposed to allow these guys to intervene. And can regulate these rights out of existence. You cannot give one permit, they're going to essentially destroy these Hawaiian practices and the resources that they depend upon. And so this case was essential in really kind of highlighting what these rights are. You cannot regulate them out of existence. And then what the developer wanted to do was say, well, he got to prove that his family, like uninterrupted from time immemorial, like before the memory of man. It was so long ago, I forget when I started this practice, that the developer was saying he got to prove that time immemorial standard, that that's his custom. And the court said, no, we're not going to do that. It's, you know, so long there's no good legal reason against it. And then he said, well, custom has to be continuous and uninterrupted. And the court said, no, we're not going to go with that definition. It's like, so you got to think of, like, over here, you know, the Kianai farmers, they get hard time grow their taro because EMI is taking all the water. So you're going to punish them that they don't can grow taro anymore, or they grow less taro, and they have to discontinue their practice and relocate to the other side of Maui and other urban places and get one job in a city. You're going to punish them because their practice was discontinued. So the court said, no, we're not going to go with that definition either. Let it be continuous. If Hawaiians like go back to the Aina and renew their practices, we don't recognize that too. And then Kapa'akai o Ka'aina, that was also a case on a big island, and it was Ka'upulehu resort development. And the developer had to go to the State Land Use Commission to ask to rezone the land from conservation to urban in order to put the resort in. So these Kama'aina and Ho'aina of that area said, we gather pa'akai here, we gather salt along the seashore, and we have all these different practices that's in Ka'upulehu. And so the Land Use Commission says, yes, okay, we do recognize you have distinct rights, so we're noting that, yes, you gather pa'akai in this area. Permit granted. So then they appealed and went all the way up to the Hawaii Supreme Court, and the court said, look, state agencies, it's not just enough for just say, okay, I noted that this is your practice, now, okay, get the bulldozer, destroy the place. Said, no, you cannot give them lip service to that. This is the protocol you gotta follow. First, you gotta independently assess. You can just say, oh, the developer said gonna be cherry, gonna be all right. No, you gotta independently assess for yourself. What are the potential impacts? What this proposed project will do? What are the rights? What are the practices in this area? It's the first thing you do. How this proposed project will impact those rights and practices. And then thirdly, you gotta say, well, what kind of conditions I can put to mitigate that so they don't lose that practice, they don't lose those resources and rights. So that's what the kapa'akai is. First, identify the practice, figure out what the impacts are, and do something about it. So what the court said is you have an affirmative duty to protect these practices. So just to sum up, where Hawaiian access rights are protected, in one's ahupu'a of residence, and if it is shown to be customary in another ahupu'a as well, on undeveloped or less than fully developed lands. And what is the state's obligation to Native Hawaiians? To ensure that these Hawaiian rights are not regulated out of existence, to affirmatively protect traditional and customary Hawaiian rights, to independently assess the traditional and customary Hawaiian practices taking place in the subject area, evaluate the impacts of the proposed action, and determine the feasible action to reasonably protect the existing Native Hawaiian rights. Okay? So we'll stop there and let you guys go eat. Do you understand what I'm saying?